For anyone who is interested in the U.S. Supreme Court case regarding the Colorado 14th Amendment question, this is the number, and you can pull this up and you can pull up the docket for all of the things that have been filed. Yesterday we had a whole bunch of amicus briefs that were due, along with the brief that was due by the petitioner. Now, one brief I found particularly interesting was a brief of U.S. Senator Ted Cruz, Majority Leader Steve Scalise, and 177 other members of Congress as amicus curiae, so friends of the court, in support of petitioner here. So this means someone, if they feel like they've got special information or want the court to know something, they can file something called an amicus brief or an amicus curiae brief, and they certainly did. So let's take a look at what they filed. I will be going through this brief in a live very soon. I will make sure to post when that will be, but just as an overall view here, they're putting out multiple arguments. First, the Colorado Supreme Court's decision encroaches on Congress's express powers, which is very interesting. Congress has expressed and implied powers here. Number two, Section 3 does not apply to former President Trump. This is very important. So under the 14th Amendment, Section 3, for anyone involved in an insurrection, it apparently does not cover presidents as an oath as an officer. Now, this is really what's got me, everybody. If the Section 3 of the 14th Amendment does not cover the President of the United States, but everybody else, we could be in a little bit of trouble. The other question that is brought up that I think is very valuable is this idea that 177 plus 2 people in Congress believe that the President of the United States is not an officer. So that's really kind of what's sticking out to me. Now, number 3 here is the Colorado Supreme Court's decision lacks neutral principles and will lead to a widespread deballoting of political opponents. Again, interesting. Go forward with your legal arguments. I'm a big fan of that. But it's this Section 2 right here, this question that Section 3 of the 14th Amendment and does not apply in this situation because the president is not an officer of the United States, I think is very fascinating. So this kind of reminded me, as I've been going through this, of another law that was passed. Let me share that with you. So this was an act that was passed by the German Parliament in 1933, and it's called the Enabling Act. This is actually the original picture of the document here. So in Germany, they had a Congress-like situation, which was Parliament. It was divided into 2 houses, essentially, and the person who was in charge, of course, of the executive branch, they had a different name for, but we'll refer to it as president in order for it to make sense with the terms of our government structure. So let's take a look at what this Enabling Act looks like and the language. And just to remind you, we've got 444 people in the German parliament that voted for it. 94 voted against, and 109 were mysteriously absent from the vote. Let's take a look at the language of this act. The first part here is going to be the declaration that it's a law to remove the distress of the people and the state, the Enabling Act here. So that's what we've got. Here's the introductory paragraph. The Parliament, or Congress, has passed the following law, which is with the approval of both houses in Parliament, herewith promulgated after it has been established that it meets the requirements for legislation altering the Constitution. They did have a constitution set up, actually. Many places had constitutions, and many people patterned their constitution after the U.S. Constitution. At this time, again, in 1933, you can take a look at that original German Constitution and how this affected it. So next up, we have Article 1. Friendly reminder, the U.S. Constitution is made up of 7 articles. So let's take a look here. Article 1, national laws can be enacted by the presidential cabinet as well as in accordance with the procedure established in the Constitution. This also applies to the laws referred to in Article 85, Paragraph 2, and in Article 87 of the Constitution. So here's Article 1. Let's take a look at Article 2 here. Article 2, the national laws enacted by the presidential cabinet may deviate from the Constitution as long as they do not affect the position of the Parliament, both houses. The powers of the president remains undisturbed. So there you go. There's article number 2. So Article 3 says the national laws enacted by the presidential cabinet shall be prepared by the president and published in the newspaper, special newspaper. They come into effect unless otherwise specified the day after their publication. Articles 68 through 77 of the Constitution do not apply to the laws enacted by the presidential cabinet. So there's number 3, and then we'll bump this up. Let's take a look at Article 4. Article 4 says, treaties of the Germany with foreign states with which concern matters of national legislation do not require the consent of the bodies participating in legislation. So their parliament doesn't have to consent to anything that's being done when it comes to foreign entities. The executive cabinet, so the presidential cabinet, is empowered to issue the necessary provisions for the implementation of these treaties. So there you go, number 4. So there is Article 4 there with the last bit of it at the top. Again, this is all in German. I'm just giving you a translation here. And lastly, we have Article 5. The law becomes effective on the date of its publication. It becomes invalid on April 1st of 1937 if the present executive cabinet is replaced by another. And then it's signed by the leaders in their Congress there in Germany. So again, this law, the Enabling Act of 1933, was voted for by 444 people in the German parliament out of both houses. And 94 people voted against it. 109 were again mysteriously absent. So if you have any questions about what 177 plus 2 people in Congress, in our Congress, how they feel about things, you can take a look at this amicus curiae brief where they set out their thoughts on executive power and the role of Congress when it comes to making different choices with regards to the 14th Amendment, Section 3 of the U.S. Constitution. Remember, 14th Amendment, Section 1 includes equal protection and due process of law. We also have other rights like privileges and immunities for the states and the right to vote if you are a male at the time and 21 and older. There are a lot of things in that 14th Amendment. It is as strong and as powerful as the 5th Amendment was, which was really that important piece when Madison was drafting the Bill of Rights in New York so long ago. There you have it, everybody. Thought I would just share some kind of comparing and contrasting of this language when we've got a group of senators and representatives in the United States Congress that are agreeing. They're signing their name to this amicus brief and agreeing with some kind of ideologies when it comes to the separation of powers in the United States and what it means. So if you think that the President of the United States is an actual officer of the United States, which according to the Constitution, it clearly states it, then this may be a little bit frustrating for you. I know there is an ongoing debate on whether or not the president is an officer of the United States, and I guess I would ask everyone themselves, to you, do you believe that the president of the United States is an officer of the United States? Because these people don't, and these people are representatives and senators sitting in Congress. So you can feel free to pull up the Enabling Act online. You can also feel free to pull up this amicus brief that has been docketed in the Colorado 14th Amendment constitutional question in front of SCOTUS. Oral arguments will be February 8th, and I'm really looking forward to it.